the satisfaction of the governor for the purpose of calling respondent 4 to be the chief minister as the head of 39 rebel MLAs of the Shivsena, which is endorsed by the Shivsena political party, is by itself ex facie unconstitutional. The Constitution prohibits recognition of rebel MLAs of a political party under the 10th schedule, and the action of the governor legitimizes what is expressly prohibited by the Constitution. The governor has sought to recognize what the Constitution prohibits. The governor is also not empowered under law to recognize who is the Shivsena. That is the domain of the Election Commission. Admittedly, recognition of the Shivsena and its leadership by Uddhav Thackeray has been endorsed by the Election Commission, and there was no dispute whatever or challenge before the appropriate authority on the 30th of June. There was no petition before the Election Commission on the 30th of June. That was filed only on the 19th of July. The Uddhav Thackeray was the chief minister of the Shivsena. So in what capacity did the governor, Maharaj, give an audience to Eknath Shinde and administer the oath of office to him? How is that the discretion of the governor to do that? Which party was the governor, Maharaj, recognizing for the purposes of forming the government with the support of the BJP? That's, Maharaj, that's the heart of the matter, and that's nothing to do with the power of the speaker now, Maharaj. This is an independent challenge, Maharaj, on the appointment of Eknath Shinde as chief minister by the governor, and the act of the governor is subject to judicial review. In these circumstances, the governor, in his ipsit dixit, guided by his political masters in mala fide, and in the teeth of the provisions of the Constitution, granted a de facto. What it does, Malas, what paragraph 3, when paragraph 3 is deleted, the governor by his action recognizes paragraph 3. He recognizes the split. This is not a stage where the government is to be formed. This is a stage when an elected government is running. So your lordships for the first time will have to decide what are the discretionary powers of the governor in that context, and can his discretion be used to topple a government with respect to a set of people who say they are split from the Shivsena, when a Shivsena chief minister is already in place and the governor does not ask the Shivsena leader as to whether you are endorsing this or not? By not asking the Shivsena, he is recognizing a split. No, there is no discretion after an elected government is formed. The government then will fall, Mullah, on the floor of the House. Then the question of the discretion of the governor will come in. If there's a no confidence motion, government falls, then the question will come in as to who the governor will fall. But the governor cannot, by his act, topple a government. No, the question is not that. When Malaj, the governor was approached, when the governor was approached by BJP as well as Eknath Shinde, and governor told us to have a trust vote, Malad. On what basis did he ask us to do that? He obviously recognized the 39, otherwise he wouldn't have asked us for a trust vote. There was no occasion to. Because they continue to be in the Shivsena. That's their own case. That they did not, Malad, move away from the Shivsena. So if they did not move away from the Shivsena, which is their own case, on what basis did the governor say you have a trust vote? Unless he recognizes that the 39 members are rebels, they have split from the Shivsena, therefore they and BJP have a majority, therefore you go and show your majority in the House and have a trust vote. That is, well, it's logical. That's the only way to look at it. And the governor must act consistent with constitutional morality. What's the moral foundation of such an act? I've already said deletion of paragraph 3. I don't have to read. Of course, it's a principle of constitutional morality. Well, then I want to just note the page, Malad, in Nabam Rebia at page 1145. 1144. Paragraph 210, Malad. Just note that. Para 210. Don't mistake the book, but just note that. I'll just read it. Last 4 lines, Malad, of that paragraph. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended.
What was the last sentence? The governor's? The last.
I'll just read it again. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the House. The governor's actions based on feuds and wrangles of a breakaway group which is not recognized under the 10th schedule cannot be constitutionally condescended. It's directly on point. Because the governor, by asking me to go for a floor test, having a trust vote, has condescended to recognize a breakaway group, expressly prohibited and the governor's action struck down in Nabam Rebia. So we don't have to go into the issue whether the matter should be sent back to the speaker or not. If you decide this issue, the matter is, nothing else is required to be decided. So we challenge the trust vote. We challenge the action of the governor to swear him in as chief minister. If that goes, everything else goes. Then we don't have to go into the problematic issue of sending disqualifications back to the speaker. And ultimately, Malad, the facts are so crystal clear that they can't be the subject of yet another interpretation. They can't be, Malad. The Constitution doesn't give him that power. The 10th schedule, he is far away, far removed from him. Para 3 has been deleted. Breakaway groups can't be recognized by that way, Malad, every day a breakaway group will be recognized by the governor and governments will fall. I don't think, Malad, the Republic expected this. And our Constitution, Malad, ever envisaged a situation that can happen in our constitutional democracy. The whole integrity of the political process comes to naught.
Rameshwar says.
MLAs, Nabam says the 3 areas in which the governor has discretion, beyond that, none. 371, Article 200, and mullahs forming a government at the initial stage after an election. There is no discretion with the governor. He acts otherwise on the aid and advice of the Council of Ministers. That's settled law. And of course, 356 mullahs, sending a report to the central government. That's not something on the aid and advice, because, so 356, 200, and 371. These are the 3 areas.
Mr. Sibal, once a person incurs a disqualification
Yes.
under the 10th schedule, then the consequence under Article 193, bracket 3, is that his seat shall thereupon become vacant.
Yes.
Because 190 in terms, 193 in terms refers to 191(2).
Yes.
Which refers to the 10th schedule.
That's correct.
So the seat shall thereupon become vacant. So suppose a group of MLAs, forget this case, suppose a group of MLAs incurs a disqualification by being a split, which otherwise is not recognized by the 10th schedule.
Correct.
So the strength of the House therefore falls by the extent of the disqualification.
Absolutely.
In which case the majority required for a motion of confidence would also be altered. So suppose in a House of 200 members, 20 have become disqualified.
Right.
Then it would be 90 instead of 100 for the vote of confidence.
Correct.
So would the governor in such a case be justified in saying that, well, I still want a vote of confidence, because assuming that these people now are disqualified, I still want to test the legitimacy of the government after excluding these persons. Can he do that?
If the arithmetic is so stacked, Mullahs, he can, but nothing more than that.
Right.
The arithmetic is so stacked, he can.
Because the consequence is that those people have to be excluded from the House.
I agree.
The number comes down, and then he can say, well, I want
Correct. So therefore, Mullahs, the arithmetic.
Minus these people who are disqualified to establish that
absolutely. No dispute on that proposition, but that the arithmetic will decide.
That the arithmetic will decide.
Here, that question doesn't arise. Yeah, we know he's made chief minister. You think by now the judges don't know he's been made chief minister? I don't understand. Well, your lordship is right, but then the arithmetic will decide. There is no discretion there. He'll call the chief minister. He says, these people are excluded. This is the arithmetic. This is what the numbers are. Prove your majority.
No, but then look at it this way for a moment. I mean, we're not at all on the facts here, but just to test a constitutional position, which is that, say or we can, just for the sake of clarity, the Shivsena has 56.
Yes, ma'am.
Or had 56 when the government was formed.
55, right? I thought, Mullahs.
Oh, sorry, 55. 55. Now, disqualification notices were issued to 22 plus 16, 38.
That's right.
So, for a moment, for the argument, we proceed with your hypothesis that this is a split and therefore they are disqualified. Right? So, then the Shivsena is left with 17.
Yes.
If these people are to be disqualified.
Yes.
So, it comes down to then 17 plus NCP has how many? 44 or how much?
54.
53. 53 plus 17, 70.
Yeah, I just see.
And Congress is 44, right?
Yes, 44. BJP is 106. Even then, it'll be fine.
Right. So, in such a situation, would the governor be justified in saying that, look, assuming that these people have incurred a disqualification, I still call for a trust vote, because the impact of these 39, at that stage, he is not deciding the disqualification. At that stage, the governor says, well, according to me, as a constitutional head, it appears that these people they have split. I'm not deciding that they have split, because that's the discretion of the speaker. Can the governor now not say in a given case that, look, these facts now stare at me. I postulate that these people have incurred a disqualification. I don't treat these as members of the House at all. But therefore, because these people stand excluded, and the strength of the ruling of the government then falls down to the extent of the extent of the split. I want a trust vote.
Well, right. Just let me analyze that in two ways. Number one, you can't then administer an oath of office to one of those who is
Yeah,
disqualified.
you're right. Absolutely correct. Your line of thinking and line of argument on this is
Okay, now let's forget that.
that we'll keep aside. Now
We'll
we're
keep
looking
aside.
at
Now,
still
Maharaj,
the power
then
of the
somebody should tell the governor that constitutionally what happens, Maharaj, from my little experience, the numbers, if stacked against the government, will go to the governor and say that the leader of the house has lost the confidence of the house.
Right.
Then he will analyze that and call. But governor will not do this. That's not his job. There's a sitting chief minister. It's an elected government.
You're right. At that stage, the governor is not really calling upon someone else to form government. But what he can certainly do is that, well, according to me, you have a ruling party with, say, which is supported in a coalition with, say, 60 members. Out of the 60, 40, which is a split. The governor says that, well, this is a split, and this is a split which is not recognized now by the 10th schedule. The speaker is going to take his own time to decide on the disqualification. But as the constitutional head of state, I do believe that with these 40, having, contrary to the constitution, moved away, at least as a head of the state, I require a trust vote on the floor of the Legislative Assembly. That I don't believe the governor would be wrong in calling for a trust.
I will say it is wrong, Mala, then I'll constitutionally provide an answer.
Why would that
The
be?
moment a governor does that, Mala, take Maharashtra. There are any number of parties apart from Shivsena, apart from NCP, apart from Congress. There are so many small parties. Now, those small parties at the moment supporting whoever is in power. The moment the governor does that, the buying and selling will start. In fact, the governor will be inviting, by his unilateral act of saying, prove your majority. There's no question of proving majority. He is the chief minister. Somebody else has to tell the governor that there is no majority. These are the signatures. These are the people who are with us. He doesn't have majority. If you allow that as a constitutional principle, Manoj, it will be disastrous for democracy.
No, but the very fact that a disqualification notice has been issued initially to 16 and 22, this is not a case where the governor is sort of, finding facts, in the political spectrum. The governor is informed, the governor knows that, well, disqualification notices have been issued to 16 plus 22 or a group of persons.
Yes.
Which disqualification, the wrath of disqualification, the moment it attaches to a very sizable portion of the MLAs who are part of the ruling coalition, can the governor be said to be not justified in saying that, well, I'm not deciding the disqualification, but now please establish that you have a majority in the House, and I'll decide whether your majority depends on these 39 or your majority is safe irrespective of these 39.
Even otherwise, on the arithmetic, the numbers are in favor of at that time, in favor of
because, Mr. Sibal, you are also right.
Independence of
Mr.
support.
Sibal, for the present purpose, because we still have to hear them on that aspect. So, as a hypothesis, we proceed on the basis that you are right, that these 39, they had really split. That too, a split is not recognized by the 10th schedule. Therefore, they necessarily have to go out.
Right.
Asking Mr. Eknath Shinde to form the government, that's a separate issue. We'll keep that aside for a moment. We'll have to hear them on that. But as an abstract constitutional principle for the governor, what else does he do?
Let's analyze the numbers now, Malaz.
Does he say that
he still has the numbers? He still has the numbers. They are only 106. There are independents. There are other parties.
No, that point is, Sybil, that is again, because, can we say that then the governor is, you see, a lot of times what happens is the governor may have done something which is absolutely within his power, something which may run afoul of constitutional principles. But we have to separate the grain from the chaff. Per se, when there is a disqualification notice moved to the speaker, in respect of a sizable group of MLAs belonging to the ruling party, How can we say that the governor is not justified in
Well,
going to the
because-
government saying, come on now, prove your...
When does a governor, well, we'll have to go into that question then, when does a governor call for a floor test? Then we'll have to go into that question. Has ever a governor called for a floor test, Mullahs, on his own, when there is a government in power? Never. Never in the constitutional history of India. Never. And the reason is simple. There is an elected government. He has proved his confidence on the floor of the House. There may be disqualification petitions.
You see, because the defection has two consequences. At one level, the defection results in persons who have defected by virtue of a split ceasing to be members of the House.
Yeah.
But that very defection, which operates to exclude them from the membership of the House, also affects the legitimacy of the government, legitimacy in the sense, the strength of the government on the floor of the House. So, therefore, the very same act, which is unlawful, of a group of persons forming a split and going out of the party fold, they incur the wrath of disqualification.
That stage would have arisen if the disqualification petitions had been decided. Let's assume, Mullahs, that your Lordship's example is right. But that stage will arise if the disqualification petitions are decided and they are out of the House.
No, but for that purpose, can the governor not say, well, I assume that they will be disqualified,
Well,
but
he
therefore
can't say.
I need I need a show of strength on the floor of the House.
But the governor has to wait on the constitutional process, the outcome of the constitutional process. Governor cannot say, I'll assume this or I'll assume that. Mullahs, I'm sorry. I mean, this is a proposition of constitutional law, Mullahs, with the greatest respect, that will ultimately encourage the kind of things that are happening today and we see all around. Please. Toppling of the government should be the priority as far as the governor is concerned.
Mr. Sibal, you are saying that constitutionally it's impermissible for the governor to take cognizance of any of those events which are all over.
Correct.
Nevertheless, he has no power to take cognizance of either the 10th schedule notices or even the earlier notices with respect to the speaker.
Correct.
Or even those representations of violation of the whip and all that has happened in the papers over.
Yes.
He cannot by himself take cognizance of anything like that at
That's
all
correct.
and ask the legislator or the chief minister to prove his strength in the floor of the House.
Correct. Because they are part of the Shivsena. They themselves say...
We are not on Shivsena. We are on the power of the governor.
That's right. Even then.
Power.
Mullahs, when an elected government is running, the constitutional principle, Mullahs, I humbly submit, is the following. If the numbers are stacked against the elected government for whatever reason, they can go to the governor and say, these are our numbers. These are how they are stacked. Governor, Mullahs, verifies that issue, verifies the signatures. Normally, Mullahs, that's a practice that used to happen, but governors now say, we don't want to enter into the political thicket. But be that as it may, that may be a possibility then for the governor to say, look, I feel that you have lost majority because these people have come to us. But governor on his own can't do that. This is no power of the governor to help in toppling an elected government. Whereas you assume governors will act constitutionally, but how many times have you struck down, Mullahs, actions of the governor who have acted unconstitutionally? And Mullahs, once that happens, Mullahs, then everybody else will get into the act, Mullahs, all those independents and all those people belonging to small parties. I don't want to say anything more. So, Mullahs, please don't lay down a constitutional principle that will create havoc.
But Mr. Sibal, suppose in a given case,
Yes.
not in this case, the majority of the people in power, correct, we were part of the government. They, along with the other party, correct, goes to the governor and says that, sir, correct, the present government, correct, has lost the confidence. We are the persons, correct. In that case, the government
cannot.
Governor can. Why? Because governor has to set.
They are still in the party, Mullahs. They are still in the party. It is against paragraph 3.
All right.
Because paragraph 3 doesn't recognize majority minority.
Apropos what my learned brother said, and I remember when we were much younger, there would be that parade of MLAs before the governor.
Yes, yes, I
I don't
remember.
see that now. That used to happen in the
now it's not
1980s.
happening
and-
anymore.
Yes.
Because that's why, my lord, is the right question, but whereas majority is now prohibited under 3. It
No,
doesn't
but
matter.
just taking the line of, the reasoning which my learned brother put forth, could the governor not say that, well, I want you to demonstrate that you have your majority in the house. All right, I exclude 20 people who have in an 80-member house. I exclude the 20. I learn that there are disqualification petitions against 20 out of an 80-member house. Come before me or demonstrate to me that you still have 40 MLAs before you.
But we could have demonstrated and we would have won. If those 40 are, even if they are excluded.
So therefore, Mr. Sibal, the governor can, even you
No,
concede
Malaz,
this,
I
you
don't agree
concede
with
it.
that proposition.
No, that the governor can certainly say that demonstrate to me that you have 40 out of 80 MLAs in an 80-member house.
It's nobody for the. It is not for the governor to say that. It's for those people in the house to go to the governor and say they have lost majority. It's not for the governor to enter into the full.
Fair enough. But suppose those people, therefore, obviously the opposition in the house would say, well, they have lost their 40. In which case, what does the governor do? At a primary level, the governor says, well, now I have learned from the opposition that you cease to have 40 out of 80, which you had originally, or say 45 out of 80, because 20 have now been issued disqualification notices, so that your strength comes from 45 to 25. Now, please, prima facie demonstrate to me that you still have 40.
Let me try and answer that.
How does the governor then
let me
proceed? What
try
does
and
the
answer.
governor do in a situation
Let
like
me
this?
try and answer that. Mullad's governor prima facie on the arithmetic of the house must first come to the conclusion that the leader of the house has lost the confidence of the house.
Absolutely correct.
How will he decide that? If somebody goes to him. Somebody goes to him and says, this chief minister has lost the majority, lost the confidence of the house because
Now,
these are the numbers.
Two sets of people could go. Either the opposition would go, or even the defecting MLAs would go. I mean,
No,
they have.
No, they can't.
Why? They will say that, well,
We don't support this government.
Hypothetical examples ultimately, when and if it comes to your lordship's bullets, because we are not dealing with that situation. We're dealing with a person who has been recognized by the governor, who happens to be part of the 39, and who has given oath of office. We're only dealing with that issue. As and when that issue and some hypothetical stage comes in, we can debate that constitutional issue. But why?
But it's not hypothetical here at all. It's a live issue here. For the reason that once the governor is in possession of facts which indicate that a very substantial.
Which is the fact that indicates that he has lost the majority of the house.
That out of 55,
yes,
out of 55 MLAs, 38, there are disqualification notices issued by the ruling coalition
15
itself.
plus 50, 53 plus. We have the ex facie, please, that's why go into numbers? Just see the facts.
All right, let's have the arithmetic.
Yes.
Shivsena had 55.
I don't know, but let's just see that.
Shivsena is for 55.
Shivsena, we'll assume it's 50.
55. Congress at 44.
PDF page 62.
Congress is
Of convenience.
Congress kitna tha?
53.
53.
No,
Yes.
sorry, 44.
44 is Congress.
NCP is 53.
And NCP.
And my request to your lordships, please call for the records of the governor whether he's gone through this exercise or not.
Yeah, that's the point you're making.
Well, please call for the records if that's the case.
And how much was the BJP? 10?
106.
And independents and other parties?
Yes. We would have been,
That will be about 20 odd, no?
But you will have
20.
to exclude this.
there would be 123. Half my mark is 124. 120.
So,
Yes.
so as a result of, say, the disqualification notices which are given to 39,
Yes.
out of 152, the ruling coalition comes down to 113.
Well, first of all, only 34 residents had written to the governor. Not 39.
Only 34.
Only 34.
34
Only,
dissidents
only
wrote to the
34 wrote to the governor.
governor. Right. So I'll
So
just
let's
39, if you
get the arithmetic then.
exclude, it comes to 120.
Eighteen to 99, 70.
Yes.
246 is the house, half of it will be 123,
Yes.
correct?
Yes.
23.
Then they'll become 126.
So,
Because then our
4 minus.
only take out 34.
How much do they have? 164?
We've now got the from Mr. Sibal 55 SS, 44 C,
Right.
53 NCP.
That's correct.
Comes to 152.
Yes.
What minus 30 now 288 is the number.
Minus 34 went to the governor.
Minus 34.
Yes.
But there were 39
No,
disqualifications.
no, but Malaz, what went to the governor? If the governor is to look at it, then he has to look at 34, Malaz.
Certainly. So 288 minus 34.
39 were in the majority.
So 254,
287 minus 34 is
288, no?
288.
288.
288 was there.
287,
One
one had
passed
passed
away,
away.
Malaz.
So 288 was 287.
Why?
One passed away.
One passed
One
away.
passed
So 287.
So 287 minus 34 is 253.
Yes.
So 253 divided by 2,
2, Malaz. 127.
127.
Yes. They don't have 127.
No, but the point is then the governor will say, if you exclude the people in respect of whom there is an allegation of defection from your side,
We have 127, Malaz, in this arithmetic.
how do you have 127?
I'm telling you, Malaz, 54, 44, 15 is 113 plus 14 MLAs, independent MLAs. In small parties is 14.
No, therefore, now look at,
In fact, Shivsena will be 21.
Mr. Sibal, look at it this way. 55 plus 44 plus 53 is 152. 152 was your strength.
Yes,
Of the basic three parties
Yes.
which form the government.
yes.
From that, instead of excluding
Plus
30
14, Malaz, there are who are supporting us. Why are you excluding?
Now,
They are independent supporting us.
fair enough. Now, 152 minus 34 also, if you take,
Yeah.
you're down to 118, right?
Yes,
Which is below the 125 mark, right? Now 127 mark, below the 127 mark. Now you say you have some independents who are supporting,
there's all in supporting us.
right? There are some independents who are supporting.
Both
There is
sides
she-
had independents supporting
Now,
them. We had 11 supporting
One
them.
second now.
One second. We're trying to look. These examples are only to see what the governor should in a situation. We are just giving.
Well, then how? Malaj is not just what. Did he apply his mind to this issue? Malaj, this is all very well. We are happening in a court of law. But did he apply his mind to this issue?
But Mr. Sibal, one thing which we cannot therefore discount, the governor has two responsibilities. One, the governor cannot enter into the thicket of disqualification. Two, the governor cannot do anything which seems to protect those who have incurred the wrath of disqualification. There we are with you completely. Equally, what is of concern to us is that the governor, in all these political wranglings and whatever goes on in the polity, there is a very high constitutional principle, which is that whoever is sworn in as the chief minister must ultimately have accountability to parliament and therefore to the people. Otherwise, what we'll be doing is that the defections have two consequences. The defectors have a personal consequence that they get out of the house, that their seats become vacant. But equally, we cannot gloss over the fact that the defection affects the stability of the government itself. And how does the governor, as the head of the state, ignore the consequence of...
Where is that question that arises here, Malaj? Where is that question, please? How does it arise here? How did the governor didn't look at all this, what your mods were putting to me. Ask for the records. So, Malaj, why go into a hypothetical situation, Malaj? with the greatest respect, Mullah, your lordships have so much experience. Let's not tread into areas which we are not called upon to tread upon. We are here as to how 39 or whatever 34 go to the governor, and the governor recognizes the 34, knowing that they are in the Shivsena. There is the leader of the Shivsena, they recognizes Uddhav Thackeray, he recognizes the split, and administers an oath of office. How does all this enter into this, into the reckoning here?
As a principle, you are saying that the governor could not have got into it, has not got into it,
Yes,
number one.
yes, it's not, yes.
And the premise for that is that the governor cannot do it constitutionally.
That's right.
He should not.
That's all that
principle
your
you
lordship
say.
is to consider. And I can understand, Mullah, I can understand the situation. There can be another hypothetical. I'm sorry.
So once there is an existing government, according to you,
Yes.
which
yes.
this was not a
That's-
government formation for the first time.
That's correct.
Then the governor, short of a no confidence vote which is brought on the floor of the House,
Yes.
the governor must ensure that the existing position continues until somebody brings a no confidence vote.
That's the only way. Now your lordships have laid that down. No longer parading, no longer comparing signatures, all that is over. So if they think, if the BJP thought that we had lost confidence, they should have moved a motion.
That is because of Bommai, which said that it's only the floor of the house.
That's
that
correct.
test and
So you move a no confidence. How do these issues come in at all? There's no discretion.
So
with the-
according to you, as a matter of principle, absent a motion of no confidence,
That's
the
right.
governor must continue with the existing position.
That's correct, because there's an elected government.
All right, we got it. I understand
Right.
what
Now, this is much worse, that he recognizes the split and administers the oath of office.
And thereafter, the floor test was subsequently.
Yes,
That is
On fourth,
yes, on 4th,
third or fourth.
including those 39.
But there, so far speaking for myself, can the governor, correct? Because under the 10th schedule, it is for the speaker to take a decision,
Right.
correct? Can the governor, correct, on his own, without any disqualify, the speaker can take cognizance that they are disqualified?
Your lordship is right, absolutely right, but they are still the Shivsena. That question will still have to be answered. What is that? What are the 39? They are still the Shivsena. So then he recognizes the split. That's the problem, Mullah. That's why the 10th schedule, that's why the whole paragraph, this is the issue. When 3 was eliminated, it was only for the purposes. Deleted, it is only for the purposes. Majority or minority, you can't destabilize an elected government. And constitutional morality was the linchpin, Mullah. So Mullah, and that's why I told your lordships, ideally the governor should have said, no further action, get your disqualification decided, then I will see. I told that to your lordships earlier.
But suppose the speaker doesn't decide.
Mullah, now, Mullah,
But listen. Suppose disqualification questions are not decided at all. In the meantime, the governor is satisfied. Correct?
can't
That,
be.
no. On the basis of the material
He
correct?
can't, Mullah, that's not his job. It's the no confidence motion in the House. How is the government satisfaction after election doesn't arise, Mullah? I'm sorry. As a constitutional principle, it doesn't arise. Don't give that discretion to the governor. You will have toppling governments every other day. First the ED will go, then the CBI will go, then the governor will exercise discretion, and governments will be toppled. How's the discretion?
It's a speaker versus governor. Speaker versus governor, as I had said. So now the flip side of it is that without any chance for all that to be panned out, the speaker shows over anxiety to take up the matter and immediately disqualify all those who are intending
Well,
to.
the speaker should decide. Your lordships have now said within 3 months. This is the judgment of this court, that within 3 months, speaker must decide. Normally earlier, but latest within 3 months. Justice Nariman's judgment was in
Meghachandra.
Meghanchal matter.
No, I was telling you about the flip side of it is, on the one hand, yes, governors over anxiety saying that, okay, you prove the majority.
Right.
On the other hand, we have a speaker exercising that discretion and says, now come on, you immediately show, I will disqualify all of you. So these are the two
But
constitutional
there's
authorities who
one is subject to judicial review, the other is not. Difference is one is subject to judicial review, the other is not.
all are subject to judicial review.
No, Malas. But once a new government is formed, Malas, if he calls for a trust, new government is formed, Malas, what judicial review?
True, true. Remedy is a different matter. I agree with you that
Yeah.
there is a remedy.
Yeah.
But really speaking, it's there.
And Malas,
What we need to interpret is the scope of the jurisdiction of the governor and the scope of the jurisdiction of the speaker also.
no, Speaker, of course, the scope of jurisdiction is clear. He has to decide the matter.
Scope and extent.
He has to decide the matter. And Malas,
Extent to the other.
So really, the governor keeps his hand
second limb of it is, how does he call Eknath Shinde to administer oath of office? Yes. No, Malas, not just kindly come to pay
But I'm
para
not
to.
saying anything right now, but factually, my learned-
Kalani, we please.
yes, all right. Factually, he
Fact-
made an
fact-
incorrect statement that there was no input given to the governor. There were 2 letters sent to the governor, which the governor has referred to in a letter to Mr. Uddhav Thackeray before he called for a floor test.
Correct,
So
absolutely.
that there is enough material for the governor to decide that this government
I
was
think
weak.
my learned friends,
have to ask the other side. What was the material before the governor on the basis of which he asked Mr. Shinde to form the government?
Malas, no, that's,
One,
Huh.
and particularly when he knew that this was really a breakaway faction of the state.
yes, how does he justify that? The question is, how do you administer an oath of office to Eknath Shinde?
It's on
No, Malas, I can understand. Malas, there's another situation. There are multi-parties, Malas. Not just in this case, there's in several states, Malas, we have a multi-party system, several parties come together. And Malas, suddenly a no confidence is moved. Malas, or somebody seeks, and in the meantime, some disqualification petitions are pending. At that stage, the governor doesn't bother about the disqualification petitions. There's a no confidence. These fellows will vote. Kindly see, Malas, the consequences. We'll take the 39 to be validly members of the House, not disqualified. Disqualification petitions pending. Move a no confidence motion. Now, they can't move a no confidence motion because the 39 will be subject to the whip. So they know that they don't have majority. Therefore, what do? 39 go to the governor. and say that now recognize me. So please appreciate, Malas, the way to ensure that the government falls is to move the no confidence. Why did they not move it? They could have, the 39 could have voted, they are members of the legislature. They did not move it because they knew that they are part of the Shivsena, subject to the whip. The government will sustain, will not fall. So the only way out was this conspiracy. And that was hatched much earlier. That's how they went to Gujarat and Assam. Having done that, they wrote that letter, which I read to your lordships, Malas. I've read that letter that, this present government, the party members are very unhappy with it. We have been not following the ideology of Bala Sahib. All that letter I read to your lordships, Malas. And then they go to the speaker. So whether it's majority, minority, it really doesn't matter, Malas. So how could the trust vote be called? Trust vote means that you have prima facie lost confidence. Governor knows that this government has not. Why we go into the matter, Malas, that the governor will presume that these people will be disqualified? Why do we even presume that? They are qualified till such time as they are disqualified. So move a no confidence. So, Malas, your lordships must ask the question, why they didn't do that? And Malas, let me put it this way. If they were so concerned, Malas, they should have voted against the whip. They should have voted against the whip. And if they had voted, this part we're over. Now, Malas, I just wanted to point out para 240. 240. The Sarkaria Commission is quoted. I just want to deal with that. Para 4.11.04 of the Sarkaria, Lordship has that. Page 101 of the Sarkaria Commission report specifically deals with the situation where there is no single party obtains absolute majority and provides the order of preference the governor should follow in the selecting of a chief minister. The order of preference suggested is an alliance of parties that was formed prior to the elections. Kindly just mark the word alliance. The largest single party staking a claim to form the government with the support of others, including independents. Then a post-electoral coalition of parties with all the partners in the coalition joining the government. Kindly mark the word coalition of parties, post-electoral coalition of parties. And then a post-electoral alliance of parties with some of the parties in the alliance forming a government and the remaining parties, including independents, supporting the government from outside. No other exception is there. Now, kindly mark this, that it has to be a party supporting for the purposes of the floor test. There has to be an alliance as a matter of law. Therefore, the governor cannot exercise any discretion. He must ask what party you belong to. I'm done with this issue, Malas. Now just two more issues and I'm finished, Malas. Number one, your lordships have now noticed that Gugavale was appointed as the whip from Assam. If your lordships agree with me as a proposition of law, that the whips cannot be appointed in this fashion. Ultimately, the Speaker, once that government is formed on the 3rd, recognizes Gagavale. Right, Manoj? And then I am issued, our legislators are issued a notice for disqualification on the 8th of July. If your lordships agrees with my proposition of law that whips cannot be appointed in this fashion, then our notices should be quashed by this court.
Subsequent notices.
Your notice.
Under 2(1)(b) or 2(1)(a).
Yes. Against us, notices against us.
Correct.
Yes, 2(1)(b).
2(1)(b).
Yes.
But they are virtually non-issue, right?
No, it's not a non-issue, Mullah. There's a notice of disqualification against me because they say Gogavale gave a whip.
You are right. You are right.
So, Mullah, it's a live issue for us.
Legislators whip,
Correct?
not the political parties.
Yes, legislators whip. So, Mullah, therefore, my request to your lordships is that notice for disqualification must be struck down by your lordships. If your lordships, of course, agree that you cannot appoint a whip from outside.
But that's the direct challenge also.
Yes, we've challenged that.
In your
That you have challenged.
38.
Yes, I've challenged that, Mullah. Now, one more point, Mullah. Your lordships, Mullah, in September, when a whole petition was argued that the Election Commission should not proceed, your lordship said no stay. Fine, Mullah, no stay. We went back. Mullah, what happened was we thought, and this is my, Mullah, we interpreted the order to mean that the proceedings before the commission should go on. Fine, Mullah, let them go on. The problem arose that we told the commission that if you take this test of organization and representation in the legislature, you necessarily will have to include 38 or 39. And therefore, if you take that into account, your outcome, your result may be that they get the symbol. But that very matter is pending before the Supreme Court about the disqualification of these 39. So please stay your hands and let the Supreme Court decide. Now, I personally feel, Mullah, that was not it was not antithetical to your lordships' order of stay. After all, the Election Commission has also to decide in accordance with law. The result was, I mean, this is again the sad part of it. The result was the commission says, I'm not going to bother about the organization. These 39 members are majority, therefore they get the symbol. In fact, your lordship's order was misused.
But we are not considering the validity of the order passed for the election.
No, I'm not asking, Mullah. I'm really saying the commission said, the High Court said, Supreme Court has said no stay, therefore they have to decide.
That to be tested in those proceedings, no?
No, that's not, but kindly see the consequences, Mullah. Kindly see how we are hurt. That's why the reference, what is the scope of powers of the Election Commission in respect of determination split within the party? Mullah, I'm not, your lordship's passed, Mullah, rightly so, according to me, that let the commission, but the commission doesn't have to, can't disregard basic principles that you are giving symbol to a party on the strength of those 39 whose disqualifications are pending.
And that issue is pending before this.
That's pending. And I said to them, please stay your hands. They said, no, but Supreme Court has said that we have to go on. That's how the symbol is given. See that injustice caused to us. I just make the point, Mullah, and not go further. And then the last thing, Mullah, kindly read now paragraph 115 with me. And then I'm done.
Para?
115 of the symbols order. 15 of the symbols.
15.
Sorry.
Para
I
15
saw.
of 15.
Statute compilation, sorry.
Important.
Page 91.
It starts, 15 is there.
Page 91 it starts, Malad. And paragraph 15
Page 103.
is at page 103. PDF 103.
To negate.
Yes. 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 Says Miller's when, Lordships have it, when
Yes,
the
yes.
Commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. Well, I'll just stop here. So the jurisdiction of the Commission starts when there is a claim that there are rival groups within the party. And it must have evidence in its possession, information in its possession, and must be satisfied with the information that is in their possession. That they are rival groups. Now, your Lordships have seen the correspondence, 21st June onwards. There is not a whisper of any rival group. Not a whisper. It's only the 39 sitting there.
So just to rephrase it, according to you, there was no information in the possession of the EC
Yes.
to show that there are rival groups,
Yes,
and it
correct.
has to be satisfied.
Yes. Now, Maharaj, the petition,
Can you just rephrase your submission, Mr. Sibal, again on this point?
Maharaj, I'm saying, Maharaj, the jurisdiction of the Commission will commence when the Commission has it in its possession information on which it is satisfied that there are two rival factions within a political party.
Right. And in this case, what is the...
Now Maharaj, kindly see. Therefore, in the context of this 10th schedule, Maharaj, now just that proposition. In the context of the 10th schedule, the only way you can get a symbol is when there are two rival factions within the party. It has nothing to do with the 10th schedule.
No, this has nothing to do with the 10th schedule.
Correct.
Right? So, Manas, there has to be a faction emerging. Take, for example, Manas, majority of the people in the 10th schedule are with Thackeray. Let's assume all 55 are with Thackeray. Then also para 15 Manas, can be invoked.
By somebody making an application.
Because 15,
didn't understand you what you're saying.
para 15 refers to the party.
That's right. So, Manas, the split has
schedule
to,
refers to
correct. The
what you do on
split
the
has
floor
to
of
take.
the House.
I'm
Right.
agreeing. Manas, I'm saying exactly
Right.
that split has to take place within the party.
Right.
That split did not take place on 21st June or immediately thereafter. Never took place. A petition is filed on the 19th of July.
Correct. 19th of July.
Just note that, Manas.
19th of July.
19th of July.
19th July, absolutely.
Correct.
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings. Minutes of meetings. Well, will my Lord allow me to just place
Start.
before your Lordships? Just give it to my Lord, please. Yeah, I will give you the copy. Kindly, please. This is on 18th July. The matter was fixed in this court on 20th July. The petitions, all petitions were to come up for directions. So from 21st of June to the 18th of July, nothing happened. No faction, no claim for faction. Just give it to my lords, please. Now, my lords, on 18th of July, just kindly come to page 7 of this compilation.
What is this? Mr. Sibbal?
Oh.
Minutes of meeting of?
Minutes of the meeting.
Of Shivsena
Translation of the Pratinidhi Sabha. Page 7. Typed as page 7, my lords.
Where is the Marathi start? Just, I can read the English.
Previous to that is the Marathi, my lords.
What page?
It says on top.
It says on top, page 48.
48.
8. 3 pages before that. Or before, my lords, the English version.
46.
Now, what do you have here? Your lordships may take it, there is no summons for any meeting, no venue for any meeting, no time for any meeting, no signatures obtained at the meeting, nothing. Just note that, my lords. No time, no place, no date is given 18 July, no summons. I suppose this is a meeting of the Pratinidhi Sabha of the Shivsena. So it must be known to everybody where the meeting is going to be. Summons must be sent like we sent to them. Right? What they do is they give a translation of the minutes of the Pratinidhi Sabha. And in the minutes, they show some resolutions have been passed. Minutes, as your lordship will know, is after the meeting. It can't be before the meeting. Right? Has to be after the meeting. So there is the minutes of the Pratinidhi Sabha, and there are also minutes of the Karyakarni. That your lordships will see at page 10. Again, minutes. Again, when it is held, what time is it held, where it is held. Yes, they say it happened, it is held in Bombay. I guess, Malats, someplace in Bombay. They must have known. Now, Malats, so 2 minutes are placed before the Election Commission. These 2 minutes.
Subsequent minutes also of what date? 27th?
27th of July. That's even more interesting. Well, just note the note 27 July. And then go back to the petition, Malats, that they filed. It's very interesting. These are the 2 documents that they placed, nothing more. Plus, of course, appointment of people. We're not into that. Convenience volume 2. Page, volume 2. Convenience volume 2. Yes. Kindly see page, PDF page 699. Paragraph 8. No. Sorry. 698. Where is that? Yes. 698, Romans 626.
PDF page?
PDF page 698. This petition is filed on the 19th of July. Just mark that, Malats. This averment is made when the petition is filed on 19th July.
What is the page number?
Page number.
698, Malats. PDF 698. And just above that, Miller's Roman 25 at 697, the last two lines of that page, if your lordship has that.
Just what is this document that you pointed out?
It says, further, a meeting of the Pratidhi Sabha was convened on 18th of July. Your lordship has that sentence? Yes. Whereby the petitioner Eknath Shinde was appointed as senior leader and Shivsena Mukhya Neta, main leader. Minutes of the meeting of the Pratidhi Sabha. So they say minutes of the meeting are there. No meeting, no place, where it was held, when it was held, who was summoned, nothing. Right. Then come to the next para. A meeting of the Rashtriya Karyakarani was also convened, whereby the Rashtriya Karyakarani has affirmed, now please note this, has affirmed the election of the petitioner as the Shiv Sena senior leader and Shiv Sena Mukhya Neta. Now this is on 19th July, and the minutes of that are 27th July. I showed that to your lordship. This petition is filed on 19th July. He says that the petitioner was elected as the senior leader and senior Mukhya Neta. The minutes are dated 27 July. This is what they filed, Manas. So 19 July, they could not have known what would happen on 27 July. And that also minutes of meeting. These are the only two documents with the commission. That's why I read paragraph 15. These are the two documents with the commission. In respect of, to prove that there are two factions arising. And second document was submitted during the course of hearing, but be that, I don't want to go into that. I'm just only interpreting 115, 15. This is the documents in their possession, information on the basis of which Election Commission is satisfied that there are two factions within the party. So minutes of meeting, well, that's...
Where are the minutes of meeting here in this compilation page, PDF page?
Yes, we just shown that one. Here, and it's not there.
No,
that's why we...
It's not an annexure.
That's why I gave that to your lordship.
Just a symbol, but that's not an annexure to the petition. Are we right?
It's not here, Malad. That's why I gave your lordship.
No.
Where are those
What
minutes?
I'm just, let me hear, my lord.
What you have read of this para 26, para 25 refers to annexure P5, which is the minutes of the meeting of the...
We haven't put it, Malad. That's minutes.
We don't have. But the petition also does it and close it is what we are trying to
Yes,
understand.
yes. That was handed over, Malad. It doesn't say. That's why we gave it to your lordship.
That is on the 27th.
Yes. So now it says 27th. This petition is filed on 29th. These are. They did enclose the second one. They didn't enclose. First one they enclosed. P5 they enclosed. So, Malad, these are the two documents with the commission. Now, if you read paragraph 15, this represents two factions in the party, the minutes of meeting. That's how the Election Commission, Malad, got jurisdiction, according to them. And Malad, this is a final order. This is kindly just look at it. I can understand if the commission says lead evidence. I can understand, please prove your case. On this basis, a final order is passed, which is the subject matter of challenge in the other proceeding. That's how they got the symbol. So what does the governor do? What does the Election Commission do? And this is the evidence. And then we have to, we must ensure, we must trust that all institutional authorities function in accordance with the law. And if this kind of manipulation takes place, Malad, in the processes of institutional decision making, where we go, Malad, where we will go, I don't know. I am done, Malads. I just want to make one non-statement. I stand here not for this case. I may lose it, I may win it. That's another matter. But I stand here, Malads, for the protection of what is so close to our heart. Institutional integrity, and to ensure that constitutional processes survive. Otherwise, if your lordships endorse such a position, it will be the death knell of what we have cherished since 1950. Thank you.
Thank you. Yes, Dr. Singhvi.
Yes, I would wish to take your lordships principally to some very interesting underlying juristic principles. Because the lordship has now seen the facts for 2 days, so I'm not going to repeat. Juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the speaker. That's going to be the bulk of my argument. But brothers, I want to start with where we are ending up, because I was here the whole morning and I heard the very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. And I'm going to repeat anything. I'm going to try and give a different facet. Well, this is a very unique and a strange case. And I would say from this side, a sorry case, where lordships has double whammies and triple whammies. Let me explain how. My Lord Mullis put the question of the governor's role. And in one sentence, the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trust vote, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock-solid principle of interpretation of Constitution and statutes is that if intentionally a constituent assembly in its amending power of the Constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is axiomatic. It is obvious a puny contract or a statute, much less a constitutional amendment, where your lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are at least two circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, the lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. In whatever way he's acting. Now, as the governor, most of all is supposed to know the Constitution. All of us are supposed to know the Constitution, and ignorance of the law is no excuse, much less ignorance of the Constitution. There is no system, and I'm not talking of your lordship's narrow question of trust vote, non-trust vote. There is no basis on which your lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. The two are irreconcilable. And that is a very major constitutional sin underlying this whole supposition and context. The second makes this even more bizarre. There is no counterpart to curiouser and curiouser. It can't be bizarre and bizarre. Well, there is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking a Lordship Justice Shah is right. We are not on the appeal on that. That's not the point I'm arguing.
Yeah, just
I'm on the
that.
context, fellas. People are here going around merely on the assumption of a split, then the Lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? I'll give the paras. There's more than 4 paras or 3 paras in the EC. We'll just give the paras. Yes. Now, Millets, therefore, your lordships and those cases don't have to be given to your lordships of elementary forms of interpretation that if I delete something, your lordship gives effect to the deletion. I'll supply them, Millets. It's not necessary to do it. The second answer, or the second Millets response in the larger context of that query. So this is the first response. The second is, Millets, your lordships decides cases. Not that your lordship decides the narrowest of narrow issue, your lordship decides the whole context. But your lordship doesn't decide beyond the context of a case. Your lordship is very careful, otherwise one of the things of biter and all that come in. And your lordship doesn't have time to spend on hypothetical questions. But let us see the context. The context of this case can be divided into broadly 3 or 4 categories. And that context makes it clear that your lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now, that will be awaiting your lordship's decision on nabab. So, phase 1 or part 1 of this context is disabling notice. Your lordship must decide in nabab. That's the whole argument we made for 2 days. But clearly, the context is that's step 1. And if that is wrong, then a lot of things fall down. And that is wrong in case a lordship doesn't agree with the literal text of nabab. The second part is that we are also forgetting repeatedly the object of the 10th schedule. Well, as more than any other jurisprudence in this part, subject of constitutional law, are cases again and again talking of 2 things: the evil prior to 84, the object of plugging that evil, the mischief rule, and what your lordship is doing by the 10th schedule. The third is that if your lordships accepts that the basic object of the 10th schedule is a constitutional sin being precluded or stopped or reduced, then 2-1, A or B as the case may be, has to be decided first. It's logically prior, to everything. Not only is it prior in terms of serial number, but conceptually it has to be logically prior to any decision of any kind in any case. I'm talking of concept. I'm not talking of a delay by an individual speaker. Whether the Kerala speaker will decide tomorrow, Nagaland speaker may take 6 months, a Manipur speaker will take, that's not the point. Conceptually, the logically prior decision has to be para 2, not a governor's intervention collaterally in any which way. That's the structure of the 10th schedule. And that scheme and structure must be endorsed and strengthened by your lordships. Inter alia, by not accepting any collateral incursion horizontally sideways by a governor, while that 2-1 is still pending. The fourth. Other aspect of this, which has to be given a lot of weight is, apart from what we just talked about, the trust vote, people tend to forget that in almost every assembly, there is a very interesting rule. You cannot bring repetitive no confidence motions also.
6 months.
Your Lordship knows 6 months. So I bring a no confidence against you, I lose it, I can't come after next week again, say I have no confidence against you. So, the next facet of this is the processes within the Parliament and Assembly have to be allowed to work themselves out first before external intervention. And one of the important processes is to notify a confidence or a lack of confidence. If your Lordship is so careful about not even allowing repetitive bites at the apple to destabilize a government, your Lordship will allow an external incursion without even a single no confidence motion. I'm not repeating, I'm giving Lordship in addition the larger context. Not even an attempt, but as they say, the proof of the pudding is in the eating. If you have the confidence, move the no confidence. It's your lack of confidence which makes you not move the no confidence. Because you know how the no confidence will be met. And may the best man win. If you have the guts and the courage, do it. Whatever will happen, will happen. That's the process of democracy on the floor. Incidentally, when I've done the maths, that chart, I mean, it is not that your Lordship will only ask them to show the material. We are having a preliminary objection that the governor doesn't come into it irrespective of the material, even if he has seen the material. I am now on concept, I am on juristic principle. There is no role of the governor till now, till whatever I have said, 2-1, etc., process, no confidence, no role for the governor. It's a second separate question on facts, what the governor saw, did not see, but he had no locus to see or not to see. So what's the point of going into down that path, fellows? The governor had no locus at that stage to see or not to see. Well, it would really amount to a very strange thing where the governor would, well, governors are now, obviously, if you read the debates of Mr. Ambedkar and now there's a vast difference. But governors are also creatures of political connection. The governor would say, well, I see a group of people here. Why are you bothered about moving? No confidence. Come to me, we will see something. There's no need for us. The assembly gets substituted. You'll be circumventing and short-circuiting the entire process of a no confidence on the floor. Yes. Now, having given that answer, let me turn to my larger point on which I was really going to address your Lordships. And give your Lordship just bullet facets, and then I will give your Lordship the material underlying it, the juristic principles as to why your Lordships should deal with the matter here. Now, I understand, that it is easier not to deal with it here. It is also equally possible not to deal with it here. There is a speaker. My Lord has heard enough facts. So, Lordship will take those facts as given. I will touch upon the facts here and there, but mostly no. In the event that the facts and the context suit your Lordship's discretion on this issue, should your Lordships in law juristically refer it or should you hear it is my respectful submission. There are four or five legal facets. Then I'll give your Lordship the case law. The first is, that there were two, one negative and one positive order by this Honorable Supreme Court. That should be remembered. In whichever way, it is worded, the negative, I'll call it injunction, on 27/6/2022 was that by the expedient of extending time, the Speaker was effectively de facto could not pronounce on disqualification. It is nothing but an injunction in substance.
Till 12th.
Till 12th, correct. Then events took over, but my Lord is right, till 12th. Therefore, let us look at it because the Lordship is always a court of substance. We can camouflage in so many forms, but your Lordship ultimately sees this in substance. It's a judicial injunctive interim relief where a Speaker's future action under the 10th schedule. That is the correct way of putting it. It is a judicial interim intervention. It's a negative injunction. And the second was a positive injunction, if I may call it, or an order of 29th, allowing the trust vote to be held. So not injuncting the second day, injuncting the first day. So there is a negative judicial intervention followed by an affirmative judicial intervention. Well, I am not making any value judgment. Your Lordship would have heard it next week, 2 weeks later. Who knows, Maharaj, everything could have been reversed. I mean, I'm not saying that at all. I'm not saying right or wrong. But I'm saying one thing is clear, that the formation of a government, I'm making a neutral statement, I'm not allocating, is clearly the direct and inevitable result of the combination of these two orders. Your Lordship would have heard it next week and upheld it. So Lordship would be right. Your Lordship would have reversed it. Your Lordship would be wrong in the interim then. That's not the point. The point is, let us not see this case in the abstract, in an ivory tower, unrealistic approach. Let us see it in reality. We have to smell the constitutional coffee, if I may say so. The reality is this, that absent these two negative and positive orders, your Lordships cannot have this consequence of a change or a new government. This will have, correctly an effect on your Lordships needing to decide this year. Then, the second aspect, I'm only giving the legal bullets, I'll cite the case law later. The second legal aspect, the juristic principle, is the language of that order. Now, we all say it casually. Sometimes your Lordship is also made to say it casually. But these are terms of art. Your Lordship has used them for decades and centuries in law. And these common law terms of art have to be given effect to. Don't go to the page, just note your Lordship's order on 29th read like this, one line, quote unquote, subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, unquote. That's your Lordship's order. This is my second facet. Subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, which means the whole batch of writ petitions. By then, many petitions had come. What is the meaning of this frequently used phrase? And normally the phrase doesn't come up. Your Lordship has some very, forget this case for just 1 minute. Your Lordship has some very interesting examples in building law and construction. Well, the first time your Lordships ordered demolition, the first time, not now, of a 20-story structure was almost 15 years ago. Ironically, I think the second one is also from Lucknow. Both are Lucknow examples which came here. Your Lordship had passed only subject to. Construction will go on. Ultimately, your Lordships held against. Your Lordships ordered demolition. Demolition, in that sense, with people living and concrete and mortar in the building, is much more irreversible than merely a political thicket or a scrambled political egg created from 22 to now. Now I come to what subject to means. The object of this phrase subject to are two and threefold. One is that your Lordship's speaks in rem, not just bilaterally between the parties. Your Lordship speaks to the whole system, to the whole world. And second, your Lordship is giving a fair warning that everything which is happening after this is subject to, but on your risk and cost. And thirdly, your risk and cost means all consequences, equities, vested rights, all status quos you create each day after that. Is it your risk and cost? We are warning you. Don't blame us later. That's the meaning, my lords, of this, and I'll cite a case presently on that. Therefore, my lords, the moment, either your lordship doesn't say it, the moment your lordship says that, no one can come and plead equities, vested rights, events, scrambled egg, irreversibility, etc., etc. Because your lordship takes into account this in advance. If your lordship passes subject to today, it is different from passing in 2022 June. The fourth facet of law, which I will develop in a moment, is that third. I'm sorry. What is third? Third. This is Malus, now. It's called pointillism, Malus. Pointillism. It's not a bad technique, Malus. It makes it for specificity and a certain amount of clarity. It may not always be. It is liable for some intellectual property protection also, Malus.
Correct. More than anything, you will know where you are going.
Now, Malus, the third one is para 110 of Quixote, which your lordship has seen right at the beginning of the Navam Rebia arguments, but lordship may kindly be reminded of that. Just turn to 110 in Malus, the first compilation, PDF page 74.
Or judgment compilation.
Judgment compilation. Or basically, Malus, the very strong constitution bench injunction when the jurisprudence of 10th schedule was starting. Quixote is Malus virtually the first. I mean, there were some cases, virtually the first, certainly the first constitution bench and the most important 10th schedule judgment at that time. Malus. They started this jurisprudence with this great warning and mandate. PDF 134 or 74? 74, the Quixote starts at 134. At 134. Para 10. Para 110. The full thing is good. Full thing is good. In view of the limited scope of judicial review, may I read it?
Yes.
In view of the limited scope of judicial review that is available on account of the finality clause in para 6. So, your lordship gives basis for it, finality clause in para 6. And also having regard to the constitutional intendment and the status of the repository of the adjudicatory power. Speaker, Chairman, judicial review cannot be available, mark these words, cannot, Constitution bench is saying, cannot be available at a stage prior to the making of a decision by the Speaker, Chairman. And a quia timid action would not be permissible jurisdictionally, threshold, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. I'll just pause here. It has some very startling consequences. If your lordship reads this, it's a constitution bench. It makes only one exception. When I, the speaker, by an interim order disqualify you, that has happened hardly ever. It has happened once or twice, but it is not really happening in the 10th schedule. Maybe that will be a new technique adopted in the future, but I don't know. But today, hardly any case. But
You are giving the idea.
No, but Quixote gave that idea. Quixote has given the idea already, but that's why I'm saying from 92 till now, it has not happened despite Quixote's idea. I mean, it may have happened one or two cases, but hardly ever happens. Yes, Kuldeep Bishnoi case, etc. But in that exception apart, it is per se jurisdictionally bad. So therefore, a perceived error of the speaker's conduct will not justify your interlocutory application. That's important. Let us assume that the speaker is wrong. Nobody is conceding that. Let us assume that the speaker is grievously wrong. That will not justify circumventing of a constitution bench by saying, normally we will not interfere, but here, by a matter of degree, I opine that he is grievously wrong, therefore we will interfere. Well, let's take an example. Your Lordship has applied that example for decades. It's not something strange at all. Quixote was, according to me, saying the obvious in a much more important category. Your Lordship has done it for lesser category. Well, as your Lordship finds genuine problems in an election process. When an election process starts, your Lordship finds genuine cases. My nomination rejected badly. I was stopped at the door by a guard. I couldn't enter. Somebody obstructed me. I couldn't file in time. This man is rejected on a comma, full stop, wrong ink. They are very compelling arguments. Your Lordship says, come after the election. In 99% cases, unless there's a special statute. Because you don't interdict an autonomous, self-contained scheme of a code there to let elections go on. Here, a much higher constitutional authority to allow unfettered proceeding further. There are many more examples the Lordship has. Therefore, the position which by a combination of the positive and the negative order inevitably led to the change of government possibly was also constitutionally wrong. Had your Lordship had occasion to discuss it in the 2 weeks following that, your Lordship would have rectified it. Today, it cannot be a bar merely because of passage of time, because this is on the face of it contrary to your Lordship's constitution bench. And a error of the Speaker was irrelevant. In fact, he hardly had opportunity to commit many errors except perhaps as a 2-day notice that would have been decided. I've cited, Lordship members, 2 cases I cited in the Navam Revia, where 3-day notices were sufficient. Yedurappa and, Yedurappa was the other way, Nayak and Balasa, Patil. Srimant Patil. Three judges, 3 days, sufficient. When the rule said 7 days, I hope my Lord remembers that. In Navam Revia, I cited those cases to your Lordship. Rule said 7 days, 3 days notice. 2-judge bench in Ravi Nayak said, okay. 2-judge bench in Yedurappa doubted it. 3-judge bench subsequently affirmed the Nayak principle, despite noting and citing Yedurappa. Then, the 4th facet is that the more important and the more general principle, but equally important, that your Lordships respects co-equal organs. There's a whole other line of cases. When I come to my notes, I've cited some of them, where your Lordships is very careful, because your Lordship now doesn't think of an individual speaker, but of the institution, where your Lordship doesn't enter into co-equal branches unless there are compelling reasons. So respect between and mutual balance between judicial and legislative organs is the other legal principle which has to be kept in mind, and all this goes towards making the non-interference principle at that interlocutory stage. Then the other facet which your Lordship in case law has used is, there may be a rarest of rare exceptional situation where your Lordship passes interim orders, not in this case, no case, I'm saying generally. Now I'm not going to tension you, to maintain a status quo. But your Lordship is very, very sensitive and cautious and careful to create a new status quo by an interim order. Maintaining a status quo and leading to the creation of a new status quo are two different principles of law looked at and dealt with differently by case law. Here clearly a new status quo was created. The 5th principle is actus curiae. Obviously, actus curiae arise in the event that your Lordship finds that I'm partially right or fully right, not otherwise. But if your Lordship finds, then your Lordship reverses the most intertwined situations, because the Lordship never allows the act of court to do any harm. Actus curiae nemine gravibit. The 6th facet is that
Seven.
if there is a right made out, I'm sorry, my
Seven.
apologies.
No, 6.
Seven.
Next. My actually, well, I dictated these later on, so my numbering is also in A, B, C, D, E, F, G, because the main submissions are below in 1, 2, 3, so I don't have those numbers. But because your lordship is right, I'll say next, your lordship will have your own numbering.
Yes.
Well, is what your lordship, I'm sorry, this is not that we are using Latin, your lordship has warned us in recent judgments against using Latin, but these are basic principles. The other one, is ubi ius, ibi remedium. If your lordship finds that I have a right, in this case a constitutional right, made out by all this which we have been arguing, then at the end of that right to say that I am remediless. The remedy which is effective and real is only a reversal of the status quo ante, as would stand immediately prior to the consequence of those two orders in June. The consequence being the change of status quo on 4th July? 4th June. 30th June is the swearing in. 30th June is the swearing. I'm sorry, not 4th July, 30th June. So it must be a status quo ante. In the event that your lordship applies the principle, obviously ibi remedium doesn't arise unless there is ibi use. If I don't have the use, I don't have the remedium. But on the assumption that I have, then your lordship will not be told it's a fait accompli.
So what would then be the consequence, Dr. Singhvi? What does the court then, logically, what would be the directions of the court?
Well, logically, the direction is that that particular act of swearing in is wrong, and your lordship will have the whole thing done again. Your lordship could then, to give a lordship, your lordship give a substantive answer.
Yes. What will be the substantive directions then?
Yeah.
Just to
now, I am giving your lordship a substantive direction. Of course, I will develop the law which is yet to come. In the event that that is correct, and that is the majesty of the law, that is what your lordship means when your lordship demolishes 25-floor buildings. And the message goes that your lordship is ultimately establishing the supremacy of the law. Supremacy of law is by no other means except by result, by actual de facto on the ground result. The rest remains paper and words. It would be a reversal of that oath. I'm being very formal and constitutionally proper. A direction.
Oath is on 3rd.
No, that's I thought 3rd is 30th. I also thought 3rd. That's why I said 3rd. Apparently, it's on 30th.
Because on 29th.
That's right.
Night
That's correct. That's correct.
Mr. Thackeray
That's
resigned
correct.
29th evening.
That's correct. Doesn't matter, 3rd or 30th, but reversal of the day before that. Second, for the purity of the process, your lordship will, there is still a deputy speaker, should decide what he would have decided but for lordship's injunction. Because your lordship is now counting the status quo ante on the but for test. But for these two orders, what would have happened? Obviously, only this would have happened. There would have been no swearing in and there would be a decision. Well, it sounds sometimes difficult, but imagine. Yes.
So far,
kindly note.
Dr. Singhvi.
Yes.
When you are on the interim injunction, not granting interim injunction on 29th and to see that the status quo ante is maintained, it was only with respect to the floor test on 30th.
And he resigned. That's what, and Roshi was asking. No,
1 minute. You can read the... on 30th, on 29th, he resigned. The order dated 29th, not granting injunction was very clear that the floor test on so and so would be subject to the floor test on 30th would be subject to the ultimate outcome. Correct? Now, in that case, correct, raise the question of status quo ante.
Yes,
correct.
I'm
on
very grateful.
On the basis of the 29th injunction or not granting injunction.
I'm very grateful for a query. Your Lordship was put it in a different way earlier. I must answer it again. It's very opportune at this moment. Mills, there are two answers. One answer I gave 3 minutes ago, Mills. Your Lordship's court is a court of substance. Always, not of form. Let me develop it. I'm answering only my Lord's query. Paramount is substance, the heart of the matter. It is true that on that day, on 29, nobody would know what would politically happen on 30th. And it is true that the technical word used is trust vote. But Mills, what was allowed to go on was a test on the floor, which is inevitable if 39 vote against. The one and only foregone conclusion, instead of suffering the humiliation of a vote, is to give up in advance. I mean, we are in a real world. There is no arithmetic, no science, no physics, which can change the result on 30th. If these people who comprise this, so the floor, I argued the matter on 29th and the earlier dates. One of the main arguments was that the moment your Lordship permits these people to vote, we were seeking an injunction. How can there be a trust vote with a tainted, how can you have a swimming pool with some part of it tainted with poison?
No, therefore your submission seems to be
that was not accepted.
That not granting the injunction,
yes,
correct, would in fact had facilitated those 39.
No, it was an additional argument, Balus. I'm very grateful. One argument was that this trust vote is, Balus, completely unreal and futile because you have not excluded the tainted fruit.
On the other hand,
the other argument was, Balus, that if your Lordship has stayed that, stay this also. That was a more important argument.
The flip side would have been that
stay both.
Dr. Singhvi, if you had faced the trust vote,
yes,
on the 30th,
yes,
these are open. There is an open vote.
Yes, yes.
Right, because you have to, because that's the whole principle of the whip. If you had faced the trust vote and lost, then it would have been clear as to whether these 39 people made a difference, how they voted, and whether that made a difference to the ultimate trust vote.
So we did not do it. It's a given fact. I can't change it. Right, Balus?
Right.
I'm answering. Balus, let me answer this also.
And the voting pattern would then determine as to whether these 39 who are otherwise facing disqualification motions,
yes,
whether they affected the trust vote or otherwise.
But I appreciate. No.
If you had lost the trust vote only because of these 39,
yeah,
then you absolutely a plausible point that, look, these disqualifications, if they get disqualified, then I win the trust vote. Isn't it?
Malus, let me. So the first part is the conceptual.
I mean, the area is not free from doubt. The reason we are putting it to you is
I,
because there is a constitutional question in our mind. That's the.
I hear your Lordship loud and clear.
Yes.
Let me, because certain given facts for us, we can't argue about. The fact of the matter is, nothing happened on 30th. The man did not, Malus, go to the trust vote. No doubt about it. Now, Malus, the first conceptual answer is, we are now, Malus, on what I have been saying and Mr. Sibal has been saying earlier were legal errors. Whether they were or not, the Lordship will decide on Malus 22nd, 23rd orders. But the argument regarding 29th order was that either you should not have stayed that, but if you stayed that, stay both. You can't stay that and allow this vote to go on.
Right.
That's the first point to be remembered.
If you have stayed the disqualification, then stay the trust vote also.
It's very unfair and uneven and non-level. Well, if your Lordship is hearing the matter next week, I believe it was on a Monday next, it was listed. Then both could have been held afterwards. The Lordship, as well as in the Karnataka late night matter we did, your Lordship said, not today, next morning, it will happen at so-and-so time. The reverse is also true. Don't have it there, have it after 4 days.
So your argument to therefore restate your argument, what you are really arguing is this, that once you stayed effectively the speaker from deciding the disqualification petition, then you should have stayed the trust vote also, because one was linked to the other at the least.
The word linked, inextricably intertwined, absolutely. And that is the answer, the first answer on the conceptual query raised by my Lord Justice Shah.
No doubt
It is
about
true. Technically, one is a trust vote, one is a floor test, one is nobody comes.
But you're right. I mean, because
Substance is
at the
what?
trust vote, those people were going to vote.
So that's the first.
That-
Now, second, no, I will go further. Since your Lordship has put a different question.
But still, Dr. Singhvi, the problem's still in your path. I mean, the problem still arises.
It would have been
that,
shown on that.
the
Definitely.
consequence of these 39 would have really.
No, so let me show
Only at the trust
Therefore,
vote.
therefore. Now, that will not affect this question. Let me be conceptually clear.
Yeah.
My Lord's query is right. But that will not affect the question I'm arguing now. That will affect, as and when your Lordship takes up the disqualification and says that we find that no disqualification occurs because we don't have sufficient proof to disqualify. That's all that will mean, Maharaj. It will only mean that I have insufficient evidence. And I'll tell Lordship why Lordship.
Nabam says, applying Nabam here, the speaker could not have decided. I mean, I'm not putting that against you, but I'm just trying to analyze.
As the principle today stands.
As the principle today stands.
Correct.
Nabam says that where a motion for the removal of the speaker is pending, he cannot decide the issue of disqualification. You say refer Nabam to a larger bench. But suppose you take this, that well, these 39, that Nabam therefore should not be construed to prevent the speaker from deciding disqualification.
Yes.
And these 39 were therefore liable to be excluded because the speaker would have been justified in hearing the disqualification, notwithstanding the pendency of the motion to remove him, that the speaker would have disqualified these 39 because, as Mr. Sibal said, it's a per se disqualification. It's a clear split. What is the ultimate consequence? That these 39 have to be taken out of reckoning on the trust vote which takes place.
My Lord is back to the chart figure.
Which these 39 have to be taken out of reckoning.
We have answered the governor point. Lordship is not coming to the governor. Governor is constitutionally barred. I'll deal with the chart in a minute. Well, today, can your Lordships proceed on hypothesis upon hypothesis? What would have happened had this happened? But I will satisfy that conscience also. Well, first part of my Lordship's
Did you not really?
The governor could have acted on that.
Did you not preclude a consideration of this argument by your own failure to face the legislative assembly?
So there are 2 or 3 answers.
Because also, I'll tell you why, and we'll rise then and we can reflect on this at lunch. Because today, what you are really asking for, and we're not saying that you're wrong in asking for it, because first principle, the court said subject to the outcome. So therefore, we have to now treat it, if we come to the conclusion that you're right, then ignore all outcomes.
And my lords have done it twice in 10 scheduled cases of big moment, twice.
Fair enough. But before a constitutional court does that, namely to set back a status quo ante constitutionally, we must be in a position to say that, well, there is an arguable outcome which would matter.
Absolutely.
Which would make a difference.
Absolutely.
If whether there would be a difference or not is really foreclosed by virtue of the fact that you prevented that difference from emerging before the court.
Why it is not foreclosed? I understand my
Let us think on this. We'll come back at lunch.
I'm deeply
Check. Mic check.
Yes, Dr.
As I start, I have one request. I want to maintain the discipline of the Constitution bench. So I'm requesting your Lordships to give me 5 minutes when your Lordship assembles at 3 o'clock on a most extraordinary urgent mentioning. I won't do it now because it's a Constitution bench. Your Lordship is fortunately rising at 2:55. So I'll do that before the other matter starts. And your Lordship will take it that I'm not abusing the process. Your Lordship hears what has happened. But that apart, now let me continue with this.
The mentioning is unrelated to this matter.
Unrelated.
Because I was only looking at
No,
the point of view of the bench. Then Justice Narasimha and I will come back for the mentioning, and then I'll assemble in the.
Nothing to do with this.
No, nothing to do with this.
Why?
Well, it's with your Lordship's permission. Well, it's a senior person, in public life called Pawan Kheda was boarding a flight today at around 11 o'clock. At the flight, inside the flight, he was deboarded on 3 sets of complaints, Varanasi, Lucknow and Assam. The section invoked is 153A, 153B, national integration and enmity between groups. And based on a statement, I'm not at all justifying any statement. I may not use that language, even not, but was based on a statement in a press conference, and sought to be whisked away. At the moment, they are at the airport, and being taken away by Assam police at Delhi airport. Therefore, till 3 o'clock they are there, and I'm showing that this cannot be a possible. We are asking for consolidation because now all over the country they are filing these FIRs, and with consolidation,
who's Mr.
stay of arrest.
Who is Mr. Pawan Kheda?
Mr. Pawan Kheda is a spokesperson of the Congress, and he has frequently had interactions with the press. He may, I will for a moment, without going to the merits, have made a statement which many people would not make. Personally, I would not make. But the statement, I don't want to. I can repeat the statement, but I don't want to repeat it.
We take it up at 3 o'clock? Or
that's all I'm saying.
3 o'clock is fine, no?
Yes, 3 o'clock.
Then, okay.
Please tell them till 3 o'clock. Yes.
Have you got some petitions?
Yes, we have got the provisional number. We'll have hopefully a diary number, but at least a provisional number in 3 sets. Yes.
All right.
Now, Miliz. Your Lordships put that question just on rising. So let me answer, ABCD, that particular question. I'll continue with my sequence after, but Lordship put that question, that had you allowed possibly the 30th vote to have worked itself out or other things, then your Lordship would have had, so to say, an actual test.
3 baje
the courtmaster. Tell him to come with the courtmaster. Now, Miliz, so therefore, you should have allowed that to happen, and then we would have had some idea, is what your Lordship put in a nutshell. Miliz, there are 5 very interesting answers to it. Directly to your Lordship, very important query. And Miliz, a related query of Justice Shah at that time. A, Miliz, this act was followed on 30th by the swearing in along with BJP persons. Just note, well, I'll make the point in a minute. Just note, 30th June was the swearing in along with senior members of the BJP. 3rd of July, 3 days later, the direct answer to my Lord's query, not on 30th, I agree. Nothing happened on 30th in terms of the vote. But exactly the same trust vote, if your Lordship will call it, or a vote of a virtually identical nature happened at the Speaker's election. Now, clearly, there is a whip, there is a direction. You can't vote for the Speaker. You are my party, you cannot vote. Voting was done. These 39 odd voted the other way. No proof is required. This is a 2-1B without going into a single fact. I'll give your Lordship the judgments. Each of these acts, your Lordship has already held in judgments to be a direct violation of 10th schedule without any facts required. If I vote for a Speaker and I'm under a discipline of my party, you can't vote for him. You don't require anything else, but you only need to see the voting. Did I press that button or not? Nothing else is required to be seen. That is on 3rd. So what my lords is saying, nothing could change between 30th and 3rd. 3 days, well, no majority would change, no numbers would change. Then the third answer is the 4th of July. Again, an identical trust vote took place for Mr. Shinde. Again, you were told not to vote, again you voted. Same people, same vote, same system, same everything. 4th of July, a trust vote in the affirmative for Mr. Shinde. So my lord has ample proof. My lord rightly said, how will we know? We'll have to go into something. This is a very, very interesting case where 2(1)B requires nothing, 2(1)A also requires nothing. Normally, your lordship, 2(1)B can be a per se completely, but something may be required for 2(1)A. Here is a case where both 2(1)A and 2(1)B are per se. Very rare combination. Fourth reason. So swearing in with the BJP, it's on cameras, everybody sees you. 3rd July speaker's election, 4th July trust vote of Mr. Shinde. Now, what is the fourth reason? Even the acts, if your lordship were to go back, these are enough. I'm only giving by way of addition. I don't need to go back. I'm now giving your lordship the seemingly contentious issue, which is not actually contentious. The seemingly contentious issue, which is not contentious, is that on 21 and 22nd of June, you did not attend a meeting despite a direction in writing, please attend the meeting. The direction is on record. Your non-attendance is on record, admitted. My lord will now look at it in demurrer. I'm trying to make it as simple as possible. No investigation, no inquiry, no evidence. Just look at it in demurrer. Second event is that you went with the BJP and others to meet the governor on 30th June. That's also admitted. It's on record, in the press, on photographs, on press reports. Admitted, no evidence required. As your lordship noted, this visit on 30th led to the swearing in, which I've already mentioned. Now, which of these will not fall foul of 2(1)A? Forget 2(1)B, Malus. 2(1)B is more per se. Malus, what can be the defense? I'm asking myself hypothetically, Malus. Your lordship will also see the practical. Yes. I mean, what can be the defense? That these photographs are forged, all the media is forged. I was in Malus Timbuktu, I never went to the governor's house. That can be a valid defense. Nobody's taken the defense, you can't. Now note two more interesting things, Malus. Rana, para 48. Lordship knows Rana very well, Malus, the Constitution bench. Specifically says that the act and conduct of going to a governor would constitute disqualification. That's Constitution bench. Citation the 2007 4 SCC 270 PDF page 834 of the first compilation.
It was read yesterday.
Only Malus para 48. So
Rajendra C. Rana.
I beg one?
Rajendra C. Rana.
Correct, Rajendra C. Rana. So Malus, this is very interesting again. The fact is admitted and the law is covered. What is it that a lordship has to do by way of an exercise is my question to myself. With great respect, nothing, Malus. Fact is undeniable, admitted, and the law is covered. And covered too by a Constitution bench. We are not saying, Malus, I can even, Malus, bow down with great respect in a very contentious issue. Your lordship says, why should we not send it back? There is no issue here. Now note the second judgment, Srimant Patil. Give the citation. Srimant Patil is the Karnataka judgment. Para 174 and 176. Para 174 and 176. The citation is 2020, Volume 2, SCC 595. 3 learned judges. This
2020.
2020, 2 SCC 595. The PDF page in the first law compilation is 1249. It's starting page, I'm sorry. The relevant para is 174 and 176. At PDF page 1307 and 1308. This holds the second point. Not attending meetings is culpable. This is the inception. 21st June and 22nd June, you didn't attend meetings. This judgment holds that not attending meetings is sufficient to disqualify. So, Manoj, in this 5 sets of facts, facts are admitted, law is covered. Now, you can always say that we want to do this, we want to do that, but if there is a purity and a social and a political evil to be controlled by 10 children, then this requires no adjudication of any kind except the formality of a notice and looking into it. And what is the, even till today, what can be the defense of this? I am prepared to accept a new defense today. There cannot be a defense to these things. This, is the light of, but I had finished on subject 2, putting to you notice and risk, on your own risk and cost, telling you in advance, warning you. Now, kindly consider, why is this principle? It is, for what the phrase my Lord is used time and again, the majesty of the law. It is not an empty rhetoric. Imagine, how much strengthened the rule of law is when your lordships in a rightful case does not one but 2 or 3 things. One, your lordships accepts fallibility. There is a line of cases of actus curiae that we were wrong. Justice Bhagwati, in a case I must thank my learned friend Mr. Shibbal to point it out, said to accept fallibility is no act of heroism. So, then the consequence of accepting fallibility must follow. Otherwise, accepting of fallibility is empty. So, your lordship is now coalescing these principles, actus curiae, ibi ius, etc. Imagine, the strengthening of the rule of law when your lordship says, demolish this building, even though we believe it's going to cause a lot of misery. The last one your lordship did took almost 6 months under your lordship supervision because 3 dates were extended. I believe my Lord Justice, Chief Justice was on the bench with us. But it happened because your lordship had a finding, had a view of the merits. And your lordship said, restoration of status quo ante is vital for the necessity for the majesty of law. Now, just see 2 striking examples in the 10th schedule when your lordships did this. We have talked about, but we haven't shown that actual para. It will tell lordships against what odds your lordship still said, no, we must uphold the law. Navam Rebia first and Rajendra Singh Rana second. And this is not at all an upholding of Navam Rebia. We are challenging Navam Rebia on the sole point of disabling. The fact that I rely on Navam Rebia for this, doesn't at all, I'm entitled, not to be hit by a stopple on that at all. Now kindly turn to Navam Rebia, just note the paras. 214.1, 0.3 and 0.4. This was the case, as the lordship remembers. Governor, speaker, preponing date. Your lordship knows now, we've argued for 3 days. Your lordship knows the facts. But see what the court did at the end. It could have found a number of reasons to avoid doing this, or not giving the answer or postponing it. Deciding not to decide is also a form of adjudication. But when your lordship is convinced of the merits, your lordship decides to decide howsoever severe the consequences. Let's kindly see this now. 214.1 is at PDF page 1158. 1158, first volume, the compilation first volume. My Lord is seen, this part my Lord is not seen. This alone vindicates the rule of law. This alone vindicates the strength of the court system, not only the apex court. And this sends a clear message that, howsoever high or whatever the consequence, the consequence must flow if your Lordship is convinced. Now, there could be no more scrambled egg in the context of 10th schedule than Navam Rebia. Your Lordship's unscrambled it. Please see 214.1. The order of the Governor of 9th of December 2015, preponing the 6th session of the Arunachal Legislative Assembly from 14th January to 16th December of previous year 2015, is violative of Article 163, read with 174, and as such is liable to be quashed. The same is accordingly hereby quashed. I'll skip the next one, come to the next after next. 214.3. Now, this is even more important. Well, remember, time had elapsed in between. Navam Rebia was decided on, give me the date. This is important, the date is important. 13th July 2016 is the decision. Show the first page. 13th July 2016. These events related to almost 8 months earlier, brothers. New government had come in. It was very easy to say so many things and not do this. But the court, if I may say, did the right thing in terms of consequence. All steps and decisions taken by the Arunachal Pradesh Legislative Assembly pursuant to the Governor's order and message of 9/12/15 are unsustainable in view of the decisions at 214.1 and 214.2. The same are accordingly set aside. It was argued, as is argued frequently, that even if your Lordship holds it illegal, the intervening decisions will not be set aside. Your Lordship hears those arguments every day from this side of the bar or whatever. But this is, if I may say, it's the constitutional walking of the talk in case, once your Lordship is convinced. Next, in view of the decision at paras point 1 and point 3 above, the status quo ante as it prevailed on 15/12/15 is ordered to be restored. That's 8 months earlier. That's why the date of 13th July versus the date of December 15, there's a hiatus of 8 months. A lot has happened in 8 months, while most of all the government has changed. Otherwise, all these principles, etc., will remain paper principles. Now, in Rajendra Singh Rana, the matter was more directly addressed as a juristic principle about you decide or send it back to the Speaker. So that's my next case. Rana is 2007 4 SCC 270. First bunch compilation of case law, PDF page 834. And I will read with the Lordship's permission, paras 12, 44, 45, and 52, 53. It has nothing to do with the law. It is to do with once your Lordship is convinced, what is the consequence? It's ibi jus, ibi remedium. It is actus cure. It is consequence. It is subject to. It is warning. All that is the point I'm reading on.
What page did you say was that, please?
The page starts, the judgment start, para 12 is at PDF page 849. 834, the case starts. Here the argument was made squarely, that kindly decide. And the rival argument was don't decide. Let the Speaker decide. The respondents, may I read this? The respondents in the writ petition, the MLAs constituting 37 BSP members who left the party, are the appellants in all the appeals, except the appeal arising out of the special leave petition filed by the writ petitioner Maurya. Whereas the respondents in the writ petition, challenging the decision of the majority of the bench, remitting the matter to the Speaker, the writ petitioner in his appeal challenges the order of remand to the Speaker. The writ petition says order of remand made by the majority on a plea that on the pleadings and the material available, the High Court ought to have straightaway allowed the petition filed by the writ petitioner for disqualification of the 13 MLAs. So squarely the issue is joined. Now come to 43. Sorry, 44, I think. 44 at page 865. Normally, and well, if I may say so, the contentious issues in this case would be far, far more than the contentious issues in my case. Far, far more. Normally, this court might not proceed to take a decision for the first time when the authority concerned has not taken a decision in the eye of the law. And this court would normally remit the matter to the authority for taking a proper decision in accordance with law. And the decision of this court itself takes on the relevant aspects. What is urged on behalf of the Bahujan Samaj Party is that these 37 MLAs, except a few, have all been made ministers. And if they are guilty of defection, with reference to the date of defection, they have been holding office without authority in defiance of democratic principles, and in such situation, this court must take a decision on the question of disqualification immediately. Well, my case has one chief minister, forget ministers. One amongst them is the chief minister, many are ministers. It is also submitted that the term of the assembly is coming to an end and expeditious decision by this court was warranted for protection of the constitutional scheme and constitutional values. We find considerable force in this submission. This is what the Constitution Bench is saying. Here, the alleged act of disqualification of 13 MLAs took place on 27th of August. And well, this is only 13. We are 39 in this case. 42 actually, well, there were 3 independents also. When they met the governor and requested him to call the leader of the opposition to form the government. The petition seeking disqualification of these 13 members based on that action of theirs has been allowed to drag on till now. It is not necessary for us to consider or comment on who was responsible for such delay. But the fact remains that the term of the Legislative Assembly that was constituted after the elections in February 2002 is coming to an end on the expiry of 5 years. A remand of the proceeding to the Speaker or our affirming the order of remand passed by the High Court would mean that the proceeding itself may become infructuous. But it may not become infructuous, but it will be great delay. Great delay, and fruits would be enjoyed for even one more second is bad enough. Here, fruits will be enjoyed for months and years. We may notice that the question of interpretation of 10th schedule, the question of disqualification raised earlier in regard to the members of the prior assembly of this very state, which led to difference of opinion between 2 learned judges of this court, and which stood referred to a constitution bench, was disposed of on the ground that it had become infructuous in view of the expiry of the term of the assembly. They will cite that judgment earlier at the footnote. Para 3 of the 10th schedule has also been deleted by Parliament. Though for the purpose of this case, the scope of that paragraph is involved. So, this case involved para 3. In my case, the Lordship doesn't even have para 3. What adjudication is required? Rana involved the pre-existing, non-deleted 3. With great respect, considering that if the 13 members are found to be disqualified, their continuance in the assembly, even for a day, would be illegal and unconstitutional. And their holding of the office as ministers would also be illegal, at least after the expiry of 6 months from the date of their taking charge of the office of ministers. We think that the court is bound to protect the Constitution and its values and the principles of democracy, which is a basic feature of the Constitution. This court has to take a decision. Now, this is important. This court has to take a decision one way or the other on the question of disqualification of the 13 MLAs based on their action in August 2003. Lastly, para 52 and 53, where they conclude finally on the result, on the factual result and the result of the case. As we have indicated, para 52 above, para 52 is 869. As we've indicated, nothing is produced to show that there was a split in the original political party on 26th August, as belatedly put forward in a later point of time. But still the plea of split was on 26/8. Now that question, Your Lordship doesn't have a headache about, no problem. On the materials, the only possible inference in the circumstance of the case is that it has not been proved, even prima facie, by the MLAs sought to be disqualified, that there was any split in the original political party of August 2003 as claimed by them. The necessary consequence would be that the 24 members who later joined the 13 could also not establish a split in the original political party as having taken place on 26th of August. In fact, even a split involving 37 MLAs is not established. There it was in 2 batches. 2 batches then. That was also the inference rightly drawn by the learned Chief Justice. In view of our conclusion, in view of our conclusion that it is necessary not only to show that 37 MLAs had separated, but it is also necessary to show that there was a split in the original political party. The above finding necessarily leads to the conclusion that the 13 MLAs sought to be disqualified had not established a defense or answer to the charge of defection under para 2 on the basis of para 3. The 13 MLAs therefore stand disqualified with effect from August 2003 Supreme Court finding directly at placetum E. The very giving of a letter to the governor requesting him to call the leader of the opposition to form a government by them itself would amount to their voluntarily giving up the membership of their party. Here they went ahead, they went with the BJP to the governor, in my case today. If so, the conclusion is irresistible that the 13 members of the BSP who met the governor in August 03, who are respondents so-and-so in the writ petition filed by Moria, stand disqualified in terms of 191, read with para 2, with effect from 27th August. If so, the appeal filed by the writ petitioner has to be allowed, even while dismissing the appeals filed by the 37 MLAs by modifying the decision of the majority of the division bench. Hence, the writ petition filed will stand allowed with the declaration that the 13 members who met the governor on so-and-so, being respondents so-and-so, in the writ petition stand disqualified from the UP Assembly with effect from August 2003. The appeals are dismissed. Well, this is really, if I may say so with great respect, the right approach for the very existence and raison d'etre of Mullah's 10th schedule and for the majesty of the law. And Mullah's, no other court can have more powers in this regard than your Lordship's court. Now, Mullah's, let me turn to some of the quotations. Now it will be more focused in terms of just quoting from some judgments. Kindly take a note, we go to the note now. Kindly take a note I have filed.
Already circulated?
A3. It's been sent. It's been sent in the night.
When you serial number A3.
Serial number A3.
There it's there.
A3. It says brief written submission. My name is there, brothers.
Yes, it is there.
Lordship, I put the date for today because there are earlier submissions. This date is today's date, although filed last night, I believe.
Submissions.
Made today?
Yes, it covers.
So what do I?
Except, Malas, I'm going to add one or two cases, as I've got only 2 cases, that you also will write in the note itself. Because, Malas, the problem is it's a ever incoming wisdom every minute, Malas. So, may I read, Malas?
Just a moment.
Numbering, because they were actually a separate note added on the top. So therefore, there is some numbering issue, but otherwise, you'll also be able to follow it. Short factual conspectus, the formation of, I'll be very quick in the first part, second part, I'll read it a little more slowly. The formation of a new government on 30th of June was the direct and inevitable result of 2 orders of the court, a negative injunction of 27th of June, not allowing the deputy speaker, a positive order of 29th of June, allowing the trust vote to be held. Order dated 29/6 made the following, I have read that quotation, subject to. Subject to necessarily and only means that A, the court issuing is acting in rem, warning that all those who act after the subject to order do so at their own risk and cost. Any consequence, equities, rights or new status quo, this is important one, consequence, equities, rights or status quo created after the subject to order will be liable to be reversed and status quo ante restored since the court has fairly put everybody on notice in advance. Well, I'll just read this case. This is important, along with a couple of other cases. But first, let me read on this section first. I'll read this Indore case, fellows. It's important. It's a constitution bench. The consequence of change of government happened fundamentally because the speaker was disabled, fettered in the interim from discharging his constitutional duties. The aforesaid disabling with the order of 27th of June was clearly contrary to a 5-judge bench in Kyoto. I have read that para, Lordship will remember that, 110. Then, Manoj, it disturbed the co-equal and mutual balance between judicial and legislative organs, the latter represented by the Honorable Deputy Speaker. Contrary to detailed Supreme Court judgments, I have quoted them below, Manoj, they're coming. These are only the bullets, Manoj, giving Lordship the propositions. The orders of 27.6 and 29.6 cumulatively and conjointly were not orders
Dr.
merely
Singhvi, if you had warned us forewarned us that you've put it down in writing, I wouldn't have been trying my typing skills, I've typed exactly all this that you have mentioned.
But well, some of this is not going to be there in terms of
Right.
answer to my Lord's query. The answers to your Lordship's query would have been oral, Manoj, therefore.
Right.
Anyway, so I'll skip, Manoj. Now, there are two principles here which I have not mentioned orally. I'll skip till J, Manoj, your Lordship. Come to K, Manoj, K. Then I'll skip again L and M. K is important. I'm sorry, J and K, both are important. J also, Manoj. If in fact an illegality has occurred, and especially after fair warning through subject to orders, the court's powers and arms are always long enough to unravel any situation, and fait accompli cannot be a defense. That's the point. Then K is extremely important, was purposive interpretation. Your lordships have interpreted 10th schedule purposively to plug all collateral and subsidiary loopholes also. Directly it is not said, but we find 20 ways of circumventing 10th schedule. Your lordship says, I will interpret purposively to prevent that circumvention. That judgment will come also. The principle of purposive, in light of repeated and comprehensive exhortations by diverse constitution benches and the legislative travaux préparatoire underlying the object behind the 10th schedule and the mischief it sought to remedy, necessitates a purposive interpretation in a holistic perspective to fulfill the true object and spirit of the 10th schedule and not allow it to be rendered a dead letter or an exercise in futility. Then, Manoj, L is Nabam, M is Rana. Right, Manoj? Now, just, fellows, you can skip para 1 in Chauhan's case. The first line of the boldface, Lordship may note, it is trite law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision. This is, Malas, the co-equal aspect. Apart from the Kyoto, no injunction aspect. So this judgment, Lordship will note, Justice Chandrachud'S and Justice Gupta's judgment. Thus, the principle of respecting the field of functioning of each constitutional functionary requires the court not to interdict either the disqualification proceeding before the speaker or the proceedings in the House. However, in the present case, that I'll skip, Malas. Then Kyoto, Malas, 125 and 126. This is not that 110. 125, Malas, just turn to for a minute, Malas, it's in PDF 140 of the first compilation.
That's okay, we can read it from here.
Yes, yes.
You can read it out and then go to 120.
Well, this is 126. I'll also just add in hand. 125 is important also. I forgot to put that. Just note that. The purpose of interlocutory orders is to preserve in status quo the rights of the parties so that proceedings do not become infructuous by any unilateral overtax by one side or the other. Then was Samir Bhojwani, a judgment to which my Lord, the Honorable Chief Justice of the party, though authored by Justice Khanvilkar, 2018. Distinction between molding of relief and granting of mandatory relief held that interim relief can be granted only to restore the status quo and not to establish a new set of things different from the state which existed at the date when the suit was instituted. You've created a new status quo that's very different from maintaining a status quo.
Yes.
Then Manas Bomma in para 8, para 115, it has, however, to be made clear, this is Manas 3 judges out of the 7, and it's part of the concurring. It is, however, to be made clear that the interlocutory relief that may be granted to such challenge to prevent the frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its functions. This is even more important than Kyoto. This is the origin of Kyoto in the 10th schedule. Bombay was not 10th schedule, but the principle is important. And this is one of 7 judges. No, 9 judges. 9 judges. 9 judges. And this is the principle which Kyoto applied to the 10th schedule. Our conclusion that Justice Sawant's judgment is part of the majority, core majority. Our conclusions, therefore, may be summarized under: if the proclamation issued is held invalid, then notwithstanding the fact that it is approved by both houses of parliament, kindly note this, it will be open to the court to restore the status quo ante to the issuance of the proclamation and hence to restore the assembly and the ministry. In appropriate cases, the court will have power by an interim injunction to restrain the holding of fresh elections to the assembly, pending the final disposal of the challenge to the validity of the proclamation to avoid fait accompli and the remedy of judicial review being rendered fruitless. Whereas Mr. Hegde never saw to live to see this benefit because governments changed twice over by the time Bomai was delivered. But subsequent to that, your lordships will notice that the exercise of 356 has decreased a lot because your lordship has been very prompt from the Bihars, the Rameshwarnaths, the Uttarakhonds, the Jharkhands to the Karnataks. It's the promptitude of the court which has reduced the use and abuse of such articles. Because retribution this way or that way, in terms of judicially deciding it, is quick. In the old days, it used to take time. Now, this Kavita Trehan is the actus curiae principle. I'll not go to it, just read the quotation. In regard to the law of restoration of loss or damage caused pursuant to judicial orders, they quote the Privy Council, one of the first and highest duties of the court is to take care that the act of court does no injury to any of the suitors. And when the expression the act of court is used, it does not mean merely the act of the primary court or intermediate court of appeal, but the act of the court as a whole, from the lowest which entertains to the highest which finally disposes of the case. Then they cite this Kedarnath. Under 144, this is the but-for test. Restore the parties to the position in which they would have occupied but for such decree or part thereof. The but-for test it is called. Nor indeed that this duty or jurisdiction arise merely under the said section. It is inherent in the general jurisdiction of the court to act rightly and fairly according to circumstances. Then, they consider the submission. I'll skip that. Come to the end of that para 23. It's a long para. The boldface is sufficient, that such a thing was achieved by an ex parte order tends to shake the litigant's face in the judicial process. That will not apply. Navam Rebia, I will skip. Now, here, before your lordship comes to the object, that is para 13 onwards, there are two important judgments your lordship will note. One is Bhuller. This is not there. Lordship may note it down on the side. These three judgments. This is not there. No, but my proposition is not there. Your lordship may, it's not cited here. First is Bhuller, Devendra Bhuller, the death convict case. 2011 14 SCC 770. It's the PDF 926. And the relevant paras are 107 and 108. Please turn to that. If there is an initial wrong, the court says, I'm sorry, 107 and 108. It's a very important principle. Kindly turn to PDF page 967 in the first compilation. Right? First compilation. 966.
What's the proposition?
If the initial wrong is found, then all consequential things must be adjusted so as to rectify that initial wrong. And second sentence is very important. This principle applies equally to judicial orders. This is very important. Please turn to 107, 108, para number. Which page? 107 is at page 966. Put it here. It is a settled legal proposition that if the initial action is not in consonance with law, I'm sorry, does my lord have it? My lord doesn't have it. It's on substantial and consequential action. The page is 966 bottom. It is a settled proposition of law that if initial action is not in consonance with law, all subsequent and consequential proceedings would fall through for the reason that illegality strikes at the root of the order. In such a situation, the legal maxim, it is given there, meaning thereby that the foundation has been removed, structure, work, falls, comes into play and applies on all scores. Now, the next para is more important. Next para. In Badrinath and Kerala, this court observed that once the basis of a proceeding is gone, all consequential acts, actions, orders would fall to the ground automatically, and this principle will apply to judicial, quasi-judicial and administrative proceedings equally. This is the meaning of majesty of the law. Well, I'll just take a little bit of time on Tuesday. I won't take very long.
You rise. On Tuesday.
Very deeply obliged.